Good evening. My name is Frank Mancina. I'm currently a student at GCU, majoring in justice studies. First and foremost, I'd like to take this time to thank Dr. Sadil and the State Bar of Arizona for allowing me this opportunity to speak in front of y'all. So without further ado, let's jump into it. Today we'll be speaking about equitable remedies. We'll be speaking about two different types of remedies, which is legal and equitable. Both are used to help someone who has been wronged, and they do it in different ways. While legal remedies are what most people think when they hear remedy, they start thinking about compensation and usually a monetary form. So if you've been hurt by someone, a legal remedy might be a monetary award to make up for the losses you have suffered. One example would be if someone breaches a contract with you, a court might order them to pay those damages as a legal remedy. And on the other hand, we have equitable remedies, which are a little more flexible. Instead of just giving you money straight out, an equitable remedy might be used to ask a person to do something about it and stop doing what they've already done. One example of that is if someone bought like a painting and you try to sell it to somebody else, they might start like an injunction, which is an order to stop them from delivering that painting to you. So both, are used to right those wrongs, while legal remedies are more about fixing things with money, compensation. Equitable remedies are about fixing things with fairness, and they're usually targeted towards specific actions. So a little bit about it, how these started. So it dates back to Roman law, as early as Roman law, where praetors would command or prohibit things from occurring. It also dates back into the English legal system, and it's closely tied to the development of courts of equity, which were separate from the regular courts of law. Back in those days, in like medieval England, common law courts were pretty rigid, and they would only offer specific remedies like compensatory and mostly monies, and they didn't have much flexibility at that time. If you had a case where money wouldn't fix the problem, say you wanted a unique item back or you needed to stop doing something, the common law courts didn't help much. So people started petitioning to the king directly, since he had the power to do more than the courts did at that time. The king had chancellors, which were advisors, that would go and review these petitions. They would begin giving out remedies based on the fairness rather than just the strict letter of the law. These remedies were called equitable because they were meant to deliver fairness in situations where the law's rigid rules didn't fit in. And so let's talk about the types of remedies. Some of the ones I'll be speaking about today are injunctions, specific performance, rescissions, and reformation. So the first one we're going to speak about is injunctions. An injunction is a court order that directs someone to stop doing something or to do something, which would be mandatory. For example, if someone is infringing on your trademark, a court can issue an injunction to stop them. There was a case years back where a motorcycle club had they were using their own logo, and a law enforcement agency actually trademarked their logo, so they weren't able to use those, and it wound up going to court, and they still wound up using it. This next one is specific performance. This orders a party to fulfill their part of the contract, usually when the subject matter is something unique. So if someone backs out of selling a rare item, the court might force them to follow through on a deal instead of just paying money. Rescission. Rescissions cancel out contracts and return both parties to the way they started. It's often used when there's been fraud, misrepresentation, or mutual mistakes. And finally, reformation. Reformation changes the terms of a written contract to match the party's true intention, often when there's been a mistake or misunderstanding. One example can be if there's a typo in the contract that states there's incorrect price. A court could reform the contract to reflect what both parties actually intended. And two cases that were very interesting that occurred was the first one being Andrews and Murdoch, Andrews v. Blake, which occurred here in Arizona. An Arizona Supreme Court case, the central issue was where Blake, which was the leasee, and through the leasee, which was Blake, and the leaseor Andrews, which exercised an option purchase of a property within the stipulated time frame. The court ultimately decided that Blake had not meaning the option, and Andrew was free to sell the property to another party due to failure to provide timely and proper notice regarding this option. So the contract dispute, some of the issues there was a contract dispute. There was timelines of notice and the court decision. So the contract dispute, the case revolved around a lease agreement with an option for Blake to purchase the property from Andrews. The timeliness of the notice was that the critical point of contention was whether Blake provided proper and timely notice to Andrews regarding their intent to exercise the option to buy. And the court decision was that Blake did not provide adequate notice within the specific time frame, therefore option to purchase had expired. And finally, the last case was Murdoch Bryant Construction Inc. versus Pearson. And Murdoch Bryant Corporation is an Arizona corporation in which they brought an action seeking to recover for fraud, breach of contract, and restitution against the prime contractor. All defendants counterclaimed seeking damages from Murdoch for breach of contract. It was tried to a jury on equitable theory of restitution. The jury found for Mr. Murdoch and against all the defendants, returning a verdict in the sum of $392,000. The defendants appealed, and they resulted in the points being approved, but the evidence was insufficient. So that's my take on equitable remedies. I hope you guys enjoyed, and you have a great day.